સાહેબ એના અંદરમાં કે ભાઈ જે તો ડિસઓનર થયો છે સાહેબ અને નીચેની કોર્ટે સાહેબ વસ્તુને એક્સપ્લેન કરી છે સાહેબ કે fact that the case section 274 of the NSS is required to be referred to, which is that section so to the substance except as to be stated when the subject case accused appears brought before the magistrate. The particularly of the offence which has been accused shall be stated to him and he shall be asked whether he is guilty as early defense made, but it shall not be necessary to claim a formal charge. તો નીચેની કોર્ટોએ બધી વસ્તુને એક્સપ્લેન કરી સાહેબ. Are the CTS check invalid bank have been advised to issue only CTS plus a complaint check from the September 10, earlier there were a separate clearing session for the non-CTS check. However, they were discontinued with the effect from the December 31st as now non-CTS checks cannot be presented in the CTS bank have been advised to withdraw a non-CTS check from the customer. However, non-CTS check remain to be valid in negotiable instrument. નીચેની કોર્ટે સાહેબ આ વસ્તુને દીધી છે જજમેન્ટ ઓર્ડરમાં અંદર બધી વસ્તુ એક્સપ્લેન કરી સાહેબ ડિટેલમાં એક્સપ્લેન કરી છે નીચેની કોર્ટે તે રીતે આ
તો સર વિડ્રો કરવાનું જવાનું મારું સર કઈ છે રાત્રે આવી ગઈશ એ લોકો કેસની ટ્રેનિંગ એટેન્ડ કરી દઈશ કરી દેવાનું છે. ઓકે તો એ વાત થઈ ગઈ છે મારી વાત થઈ ગઈ એટલે એમને ખાલી એટલું લેવું છે કે જે મેલ છે ને એની નીચે ખાલી વિડ્રોનું મેસેજ લખી દે તો કરી દો ને
બંને રિલીજન છે સાથે રસ્તામાં
There are whatever issues are there before the court. First of all, I have filed an application for discharge. Now, I am covered under the new act, PNSS 25, after this 1st July 24. So, as per 274, which was equivalent to
before issuance of process.
Yes, here there is a provision. That is exactly what was my submission before the trial court. That first I was appealing whether, because of that Adalat process judgment, whether my application is maintainable or not. Court said that no, your application is perfectly maintainable. So as far as maintainability is concerned, 274 is very clear. As per the new BMSS. 274 of BNS is very clear. I just read that when in a summons case, the accused appears or is brought before the magistrate, the particular the offence which is accused shall be shifted to him. That is the plea part. And he shall be asked whether he pleads guilty or has any defense to make. But it shall not be necessary to frame a formal charge, provided that if the magistrate considers the accusation as groundless, he shall, after recording reasons in writing, release the accused, and such release shall have the effect of discharge. So these are the wordings of 274, which was never there earlier in 251. TRP. Now, so the maintainability was not the issue at all to the trial court. Now, what has happened is that court has considered that Karnataka judgment on its own so moto. But in that judgment, there is not only one reason that non-CTS check. There is reason of funds insufficient. Along with that reason for dishonor. Here, in my case, I'll just point out this application for discharge which I have given in both the cases.
कर्नाटका जजमेंट रिफर करो कहाँ पर है?
Okay. Just I am now here only relying on their own documents, not my documents. page is 45 or 25, which I have given this compilation, application for discharge of the along with the revision. Okay, I got that. And see, after this complaint, the very first document which is there before the court is the check. In 45 or 25, the check. It is very pertinent to note that there are two checks, two cases, and checks are of different banks. It's not that the checks are of same bank. Checks
Both.
are of different bank.
Both checks.
Both checks, Bank of India and Kotak Bank, Kotak Mahindra Bank. There are two different checks. His case is check is given, so liability is there. That is his submission. But I am relying upon both the banks. The cases checks are different. Banks are different. Now on the next page, this is their document. Their bank is Bank of Baroda. Complainant's bank is Bank of Baroda. When this deposit slip is filled up by complainant, this is his deposit slip. There only bank has put a remark on that deposit slip itself. Non-CTS check, non-deposit in clearing. Next is their own
Endorsement क्या है?
endorsement for written memo of their bank only. Bank of Baroda only. His bank only. From drawer's bank, accused bank, there is no document. Non-CTS check not collected through clearing. Non-CTS
CTS check.
not collected through clearing. So, in short, it is their own document which clearly shows that the subject check is never presented by their own Bank of Baroda for encashment in the bank of accused. It is not presented itself. And there they have prepared this advice. Rather, it's an advice, not a written memo. It is an advice clearly giving back the check. Because, also I point out, this truncated system is what earlier RBI, the check used to go for clearing. Behind the back of the check, there used to be a specific number that this check has gone for clearing with a date and timing. That was stopped. Now what has happened is, it is all digital. So after this 1st January 19, the check is, the photo of the check and the reverse part of the check is forwarded to the other bank. It is that system of truncated. It is very clear as per the RBI guideline. So since it is a non-CTS check, they returned it back.
Okay.
So it is not a valid instrument. In the order which is relied, this judgment of Karnataka, and may be having, are you having that copy of that Karnataka judgment? So the check has not gone for clearing, basically. In both the matters. In both, it is the same endorsement. Now I have annexed my bank statement also to show that next is the Kotak Bank. That the bank statement is very clear. I have
That you have got
operating both the accounts.
You have got sufficient fund at the time of.
Fund is not the issue at all, because I'll point out October 15, my account, this Kotak Bank account was valid, was running account. Running in the sense I am not operating it, but it is not closed. So October 15, then March 25, okay, the last document of revision 46 of this document of 46. In this 46.
Okay.
Last document is the bank statement of total. In this combined. Yes, yes,
Yes, sir.
on the last page of this statement, when you see this document, this account is still open. The last page of 5th October 15 is the second last entry. Correct, Your Lordship? Now, next entry shown is 24th March 25. So 10 years, the account was not operating. I have not had any transaction because I am doing transaction in another bank.
Another.
So if that was so, when he deposits on 3rd March, at least if the check was presented, then debit charges must have been levied by the bank for return of this. Now, when it has never come in this bank for presentation, the question is that there is no dishonor. There is no dishonor.
And without the return memo,
Without return memo,
he cannot file.
without presentation. Lordship,
Check must be presented for clearing.
check is not presented for clearing, in short. Lordship, this Gujarat High Court judgment is very clear on this issue. Lordship, this is the Karnataka High Court judgment. In this, only issue I would like to point out is
The check was returned with
funds insufficient in that judgment.
where is it? Where it is mentioned?
This is a observation by the trial court also. Just see this.
Nowhere it is mentioned that the funds were insufficient.
In that judgment, na?
Calcutta, Karnataka judgment.
Karnataka, that is what I am looking for. Okay, now the court has observed in the order. Now, on its own, how it has come that funds is sufficient and a valid instrument is a part of it, no doubt. But as far as the observation regarding funds insufficient is not seen. Because here in the impugned order, Rohit versus there was no.
में एक ही फाइंडिंग है कि भाई एक 2019 के बाद भी still be a valid negotiable instrument.
Lordship, that is on a different footing, absolutely, where your Lordship, proceedings are pending, suppose a case is pending since 2017, and till that the trial is not culminated. Then it will be treated as a valid instrument because it was presented before 1119. That is my submission. And even if suppose an appeal is pending, if appeals are also pending, then that date of the check on that particular day it was valid.
Yes.
So by virtue of this date of 1119, the earlier proceedings cannot close. In this lordship is having this Karnataka judgment. I cannot find the prime, the fund interest.
Nowhere it is.
Nowhere it is mentioned, but court has observed that way. Now this Gujarat High Court judgment lordship is very clear.
Hmm.
It was on a point.
Hmm.
Check was deposited. Earlier the validity of check was 6 months. Very clear.
Hmm.
So he deposited on the last day in his bank, complainant. Complainant deposits in his bank on the very last day. 24th was the date and he deposited exactly
within
on
time
24th
limit.
in his bank. But it reached the bank of the accused after 4 days.
Hmm.
So the court has observed very clearly. I'll point out the 4th page. Onwards it is there. It is very clearly saying that the complainant bank is merely a collecting bank.
Hmm.
It is collecting the money on behalf of complainant. And the drawer's bank is the paying bank. So when the check reached the drawer's bank issued a remark, it is a stale check because it was beyond 6 months and 4 days. It is a stale check. So as per the accused in this case, the submission was that since it was outdated, beyond it became an invalid instrument, and that's why the bank has given that remark. So the court has held in this case that it should reach the bank of the accused within 6 months, not that you presented in your bank on the last day you are absolved of compliance. So it should reach the bank of the accused within that last day. That is a short submission in this. And this entire judgment lordship is on this point only, the collecting bank and the paying bank. So the complainant's bank is the collecting bank which ought to see that the check has been presented in time.
But time is not a matter.
Here it is not here, but my submission is that it has distinguished that the role of both the banks. Also, what it means to say is that it should reach the bank of the accused, drawer's bank, so that the payment can be made. When the check has not reached the bank of the accused for encashment, so my submission is there is no discount. And on this is based on documents itself before the court. So it is not a question of fact. Court has held clearly that it is not a question of fact. On the basis of the document itself, it can be considered.
Which part of this judgment you are relying?
Yes, sir. 4th page onwards is the entire provision. I'll read from the second last page. Last 10 lines. The second last page, the presentment is late by 4 days. Is mentioned. The check therefore becomes a stale check and the same bounds without honoring the same. As the presentment is not in consonance with section 138 and is late by 4 days, one of the essential requirements for initiating penal action is not satisfied. On that basis only, court has dismissed the complaint. In short.
But here in this case, this
No, I'm only on the point that it has distinguished the role of the banks, of each bank, drawer's bank as well as drawing's bank. And it is not a question of fact, because on the basis of document itself, now let's say I have annexed the bank statement also. In another bank, other bank statement is also there. It is that account was closed in 17. And his case is not that there was any transaction with him. Both his complaints are saying that it is cash transaction. See, earlier there would have been any cash transactions with him.
2017 में अगर बैंक अकाउंट क्लोज हो गया होगा तो
why would I issue the
तो
check?
क्लियरिंग में जाता जब भी चेक तो अकाउंट क्लोज के एंडोर्समेंट से वापस आता ना वो
Exactly. So
लेकिन वो
it is
नहीं
not
हुआ
gone.
भी नहीं है।
It is not gone for. That is my submission. Because see, if he was able to show by any bank statement of theirs that he had any transaction with me, but he has made some payment to me, and I had a transaction, then it would be a different footing. His entire case is one check is 5 lakh, one is 6,23,000. Both are pertaining to cash transaction. That is my submission. So virtually there is no presentment of check and there is no dishonor. So non-compliance of 138 A, B, and C.
ट्रायल कोर्ट के जजमेंट में कहां पर है वो इनसफिशिएंट फंड वाला?
That is what I was.
Because in Karnataka judgment there was no mention.
Karnataka judgment, I see only non-CTS is mentioned.
Only non-city.
Yes, yes, but here I'll point out.
And the question before the Honorable High Court was very narrow, that it is a valid document or not, valid instrument or not.
Yes, sir.
We have got another issue.
Exactly. But
If it is valid, then offense is made out or not.
valid or not, but Lordship may be aware of the judgment of Desai of Supreme Court, which is subsequent to this judgment. 2002 somewhere, Ishar Alloys versus Desai. On this point itself, it is same. Supreme Court has had this, that it has to come in the bank within the 6 months. Confirming basically like this judgment, not from this order, but in another case. So the wordings are very clear as far as the roles of the bank is concerned. So unless there is no presentment of the check has to reach the bank of the drawer. It has not reached.
Presentment in.
He has given it to his bank. What his bank is done?
He presented his check.
No, he has not presented. He has just handed over. They have there and there made an endorsement that this cannot go for clearing and given it back. It is their document.
In one case, the endorsement is on the receipt of the first receipt.
Both the matters. It is there is this
in another,
both the cases.
In another case,
same way.
The endorsement is on a written memo.
No, it is both. In both the
written memo. આપણામાં તો રજૂ જ નહીં નીચેની કોપી મંગાવવું પડશે પહેલા રેકોર્ડ મંગાવવું પડશે ત્યાં સુધી નહીં ખબર છે.
It is written memo in
in written memo.
Both it is the same.
In another case,
this is of Kotak Bank. This is of Kotak Bank revision 46. I'll point out. I'll just show.
So bank has given the written
on the counter, given it back. It is that way, Lordship. He has gone for, he has filled up the deposit slip.
बैंक में written memo तो दिया.
Written memo, it is not written memo, it is advice, Lordship.
In your word, it is advice.
But it is banking parlance, I am saying. Written memo is issued by the Drawers Bank. And when
Drawers Bank to the bank of
to the bank of the pay. Bank of Pay's bank.
He is saying that was the subject matter of at the time of evidence.
No, how it can be? Because that is why I am relying upon this Gujarat High Court judgment. That on the basis of the document itself, it has never held it is a matter of trial. It is not a matter of trial because there is no document of my bank which he is relying. Lordship, he is not relying on a document of accused. He is relying his own document, and this is part of the complaint which he has relied in the complaint. I'll just point out. There are two memos.
Same day it was issued. The advice note.
3rd March 24 is this presentation. Is there with their own memo or advice, whatever it may be called. It is there.
The paper is a written memo.
Written memo, but it's of Bank of Baroda. Bank of Baroda is the bank where he has given the check. His deposit slip is
non-CTS check, non-collectual.
Yes. Non-CTS check.
Non-collectual.
Not collected through clearing.
Through clearing.
And on the deposit slip, next page, It is very clear mention, non-CTS check not deposited in clearing. Deposit slip, your lordship. This small deposit slip.
Yeah.
They themselves have written. So when he fills up the slip, there and there, the bank gives it back.
Non-CTS check
Not deposited in
not
clearing.
deposited in clearing.
In clearing. So it is
मैंने
like
भेजा ही नहीं उसको, क्लियरिंग के लिए उसको
it-
सबमिट ही नहीं किया.
See, it's because of this truncated system. What is the issue is that when that banker will show this image to the other bank, he will say, "This is non-CTS. Why are you showing me?" It is basically barred from showing also the image of that check because the checks here after January
1/1/2019.
are different checks.
Okay.
So in both, your lordship, it is their own document. So it cannot be a question of fact that it is a matter of trial or that it has to be only by leading evidence.
अच्छा अभी दे दो आप लोग नहीं. So your argument is not presented for clearing,
So there is
no dishonor, and hence no offense.
Absolutely, there is no offense because there is no presentment. No dishonor, basically. If that fund is insufficient, I'll just point out.
In Karnataka judgment,
In the Karnataka judgment, this one Himachal judgment also was relied.
Himachal judgment is not produced.
Now, I'll just continue.
In para 8, it was held that still be a valid as a negotiable instrument.
That is what exactly Your Lordship, but Your Lordship has come to the.
Before 1/1/19.
That's what my submission is. That is for only for pending litigations. Where the cases are pending, whether
Not for a new,
it won't be
not for a new.
Yes, it won't be that retrospectively seen, but pending matters will not be closed. That now this deck has become stale, which were the subject checks before 1/1/19.
Show me insufficient fund in trial court judgment or in Karnataka judgment,
Yes,
where it is mentioned. Because you both are arguing that it was mentioned.
yes, yes.
Help me.
I'll just go through it again.
On last line of this para 10. However, non-CTS checks remain to be valid as a negotiable instrument of Karnataka judgment.
Of Karnataka.
Okay, funds
I'll just point out, I have just come across this Himachal Pradesh judgment.
Okay,
where
new
this
judgment.
Karnataka judgment is referred,
Okay.
Rohit Kumar. In this last page, para 19, it is mentioning it was dishonored with the endorsement funds insufficient as per para 3 of the complaint. Therefore, the complaint cannot be quashed at this stage. This is the finding by this, considering this judgment of Karnataka High Court.
Karnataka judgment.
Lordship, this
Ah.
judgment, in which
Karnataka-
we don't find.
Yes.
That insufficient fund is
Karnataka judgment is on a very narrow issue.
narrow issue, but Your Lordship,
And it is only pertaining to the validity of that particular check.
I agree, but then the binding principle will have to be seen. If there is any judgment
Your argument non-presented, not dishonored,
Yes.
hence no offense.
Yes, Your Lordship. So
Okay.
if there was a judgment of Gujarat High Court
Gujarat High Court
on this
judgment
issue,
is
on this non-CTS check issue, then it would be a binding whether allowed or not. That was the
Gujarat High Court judgment
But-
is also on a different aspect.
aspect, but it is only on the point of clarification regarding the role of the banks. That is my answer.
એ કેવું બીજું
ઓલરેડી કન્સલ્ટેટિવમાં જે મેડિકલ સોલ્યુશન જે નોટિસ છે એ દાખલ કરવા પહેલા એ વખતે એમણે કોઈ જાતના મુદ્દા રેઝ કરીને નોટિસનો જવાબ આપ્યો નથી સાહેબ. આ મુદ્દાઓને
You have answered the notice of statutory
I have
notice.
answered, Lordship. Now I am only pointing out one. Lordship has asked the complainant whether the reply was given or not. No, I have said in one case I
now
have given.
it should be on record.
It should be.
If you answered, the answer should be kept with the
I'll point out, Lordship,
complaint.
where that stage come. For me, there was no opportunity to bring it on record because defense evidence is not the stage where in my 313 statement.
You are arguing today that there was only cash transactions and so and so. So because of that reason, he is asking about the reply. Have you mentioned in the reply?
But Your Lordship, when a person is making a false statement across the bar, in one case I said I have given a reply. One case was beyond limitation. By the time the client handed me over the notice, 15 days was over.
In
So
one
I
case,
said-
you have filed reply.
Yes, Your Lordship. So that 15 days was over. So it was no sense giving a reply because that offense was already complete as per law. Now, in one case, when I have given a reply, my learned friend is not relying in the complaint, first of all. And secondly, when Your Lordship has asked specifically that reply, he says in the complaint, I have said, and hence there is no reply. Then Your Lordship, where is my occasion to present that document before the trial court, first of all, or before this honorable court also? If Your Lordship, as per law I am going, my document will come only
That stage,
at my defense
that
stage.
stage permit you only at the time of trial.
Exactly, Your Lordship. Exactly.
Okay.
Please.
What order?
Please.
9 January.
Please.